Thank you so much. Now, firstly, everyone can hear me? Good. I am recovering from a definitely not COVID cold, so you've got really husky voice today, so you're welcome. Enjoy. So today, as usual, for those of you who've been here before, I'm just going to give a bit of an update on what's happened in the last 12 months in relation to law and the online world. If anyone has any questions at the end, please feel free to throw them at me, but also equally feel free to throw questions at me during the presentation so we can make Jen run around with the microphone. So I encourage you to do that as much as possible. As Rubina said, I am a lawyer, but this is not legal advice. Do not rely upon any of it. It's just amusing sounds at this point in time. If you need legal advice, please speak to a lawyer. And if you need Microsoft Paint skills, you can get in touch with me here. I thought there was a different slide there. I'm just going to check something. We might have a potential issue if this is not the right presentation that I've uploaded. Let's find out. What you don't know is that I actually submitted my application to speak next year before this presentation, just in case that happened. So they've already got my submission. They can't pretend that I didn't. So let's see if we can get the clicker working. That's what I was expecting to see. That is the new image, Microsoft Paint skills, destroying marketers' dreams every day of the week. Now, when I came up here, I had 720 Twitter followers. The challenge is to get me to 1,000. You don't have enough people here to do that, so you need to go pressure your friends to get me there, just to make me feel better about myself. So let's go through the update today. Everyone who's seen me before knows I like encouraging people to raise their hands. Is anyone willing to volunteer? Prior to 2021, how many laws were specifically directed to social media and internet use? And I'm not talking about things which are just, the criminal stuff in the telecommunications laws and things like that, but specific social media laws. Anyone want to volunteer a guess as to how many there were? Australia. We had a zero? Zero. So because of that, the way in which the law regulates digital activity is using awesome old laws and old cases that have nothing to do with the internet. So from lighthouses, we get laws about e-safety. From fax machines, we get copyright. From pin-up boards and graffiti walls, we get defamation laws. And we're seeing in the last 12 months, all of these different types of arcane, old-school pieces of legislation and case law being pulled out and freshened up in the social media world. So in the last 12 months, we've seen amendments being made to the Defamation Act, which is great fun, keeps me busy. Court rulings that changed online responsibility. There have been some proposed changes to the Privacy Act and lots of social media cases. Now, I tell this case story every single time because firstly, I love it, and secondly, it explains digital responsibility up until 2 years ago really well. Does anyone here remember what this case is? You knew this was an exam, right? Anyone willing to volunteer what allergy pathways was about? I'm really glad to hear that everyone who comes to these presentations listens to me. It really makes me feel good. So look, Allergy Pathways was a case about a company that was promising to be able to cure allergies via a combination of acupressure and homeopathy, which is great, except it had no science or evidence behind it whatsoever. So they were instructed by the ACCC to cease claiming to cure peanut allergies by prodding people, and unfortunately didn't, and so they were taken to court. But when they were taken to court not just in relation to what they had said online, but also in relation to what their customers had said online. So there were posts on Facebook pages, there were comments on their blogs, there were tweets about this service saying it cured my allergies, it's amazing, and the court said you're responsible for that. Now, Allergy Pathways said, hang on a second, we didn't write that, we didn't ask those people to write it. And the court said, well, maybe not, but you should have known that it was there, you didn't correct it, and you didn't delete it. And so we got to a position where the standard point of the law was, if someone posts something on one of your social media or digital channels, you need to respond to it within a reasonable period of time. And that response can either be to delete it, to make a corrective comment, or to otherwise moderate it in a way that corrects the invalid statements. And this can be anything from defamation through to misleading and deceptive conduct, copyright infringement, etc. So that was the way the law was for quite some time. Now, however, things have changed. And they've changed in a variety of ways in the last 12 months. At the conference last year, we were almost at the point where things changed, but they hadn't quite. So let's first of all talk about defamation. Now, before 2005, defamation laws were state by state. So if I said something in South Australia and it was defamatory here, it might not be defamatory in New South Wales or Western Australia. But in 2005, they decided that what we should do is have a uniform defamation regime, which means that whatever is said here is the same as what's said interstate or interterritory, and it made things a lot simpler. And so in 2005, everything changed. And there were also some other really momentous things, but none as momentous as the Defamation Act changes. And it established a regime where, in order for there to be defamation, and just to clarify, defamation is something that is said about you that makes people think that you are less than you are, that it harms your reputation. But in order for something to be defamatory, there had to be three elements. Firstly, there had to be publication. So you had to have said it to someone other than the person you're talking about. You can come up to me in a room and say, you are the worst presenter at this conference, and whilst you might have a defence of justification, which is that it's true, it is not defamatory in any event because no one else heard it. The moment someone else is there, or the moment that you say it to someone else, and that can be verbally, in writing, via smoke signals or interpretive dance, then you have published that content. The second question is, have you identified the individual? So if you have either named the person that you're talking about, or if you've given enough clues, like that guy who gave the wrong presentation to the organisers at Digital Adelaide, that would be sufficient to identify who I am. And the last thing is that it must lower people's estimation of me. Now, in reality, there's not much you could say about me that wouldn't already, would go below where I currently am sitting at the moment after this morning. But if you say something that damages my reputation, that is defamatory content. There are, however, as I said, some kind of defences. So firstly, if what you say is true, that idiot forgot to send the right presentation, that's not defamation, it's true. It could be your honest opinion. Wow, that guy's really disorganised. It's true, it's honest. It could be trivial. So who's really going to care about what is said? And then there are the complicated ones like qualified and absolute privilege, which you don't need to worry about too much. What has now changed is that last year, there was an agreement amongst all states and territories to amend the Defamation Act. First time it's happened since 2005. And they've introduced a few different elements, and one of them in particular has a major change for online commerce. So the first thing that we've got is that there's a new test called serious harm. Now, if you want to sue someone for defamation, before anything else happens, you must prove to a court that you have suffered serious harm. And that can be mental harm and anguish, but not just being upset, but it has to be serious. We're starting to see a couple of cases come out to show what that means, but it's still a little bit murky. There's a new defence of public interest, which is brought in to protect journalists who might, I don't know, want to publish articles about former Attorney Generals and what they may or may not have done in the past. That is now a defence. And then the last one, which is the most important one, is called the single publication rule. If you want to sue someone for defamation, you must start your case within 12 months of the time when the content was published. There's potential to extend to 3 years, but in reality, you've got 12 months. So if someone said something about you that was nasty 2 years ago, there's nothing I can do for you. Up until now, however, online was different, because what the courts had held is that every single time a new person clicks on that content and sees it, there is a fresh publication. So you could have content posted 10 years ago that is still able to be the basis of a defamation case now. The single publication rule changes that. It says that the first time a third party sees and reads the content, the 12 months starts ticking. And that is great for people who are worried about online responsibility because it means you only have to worry for 12 months after you've posted something, rather than thinking about your back catalogue of heinous comments that someone might at some point in the future find. So that was a significant change. It has come in most states and territories, but not all. Sorry, I'm going to step back one. The next thing that we've looked at is a question about when things are published. So I've just gone through allergy pathways and how that was the way the law worked. And the key question there is, did the company whose asset was posted on actually publish the content themselves? Were they responsible for what a third party had said? And as I mentioned, if you didn't do something within a reasonable period of time, then that is enough to make you responsible. And the law in this area really dates back to old school public notice boards. There's a case in 1937, this is an actual picture, as you can see it does include the classic 1937 PlayStation poster, where a country club had a notice board and someone posted something defamatory, literally put a piece of paper up saying so-and-so is a jerk, and the country club was found responsible for it because they hadn't taken it down within a reasonable period of time. And it also could happen whether it was posted overseas or in Australia. The case of Dow Jones and Gutnick showed that things posted in the Wall Street Journal in New Jersey were defamatory here in Australia. So it was reasonably broad, but we had a very reasonable test. If you're a multinational, you're expected to act on these things quickly. If you're a two-person outfit, you probably need to be looking at your socials once a day. Then this happened. Now, that's an image of Dylan Voller, who is a former detainee from the Dondell Detention Centre. You might recall there was an incredibly confronting image of him tied to a chair with a spit hood at that detention centre some years ago. Now, when Mr. Voller was in the press, a lot of news agencies posted to their social media platforms with their stories. What they had posted were legitimate news articles. However, they were open for comment on those pages and people just posted vile and disgusting things about Mr. Voller. None of which was justified, all of which was abhorrent. Voller made an interesting decision. Instead of going after either the platforms, so Facebook, Twitter, etc., or going after the individuals who were keyboard warriors writing nasty things about him, he went after the media companies. And he didn't give them notice. He didn't write to them and say, hey, guys, this is a little bit unfortunate, can you please take it down? He just sued them. They came back and said, wait a second, you didn't tell us about this. We didn't know you were upset. Why should we be responsible for taking it down? And in the first instance, so you had one judge talking about this, he said, no, they're responsible. And they're responsible from the second the content is published. So the moment that a third party reads content that has been posted on your page, you are responsible. And the marketers cried out, but there's no moderation option on Facebook. How can we possibly handle this? And the judge said, well, you've got your profanity filter. Just put in every word known to the to humankind in that and it'll be fine. Not thinking that, people might get creative with spelling or, post images that wouldn't be caught by that filter. But that's where we were sitting initially. However, it was on appeal. And last year, when I was talking, we had got to the point of it being at the full court of the New South Wales Supreme Court. So 3 judges, highest court of New South Wales, who upheld that decision. Since then, it has now gone to the High Court. That is apparently a picture of the High Court. I have not been inside it yet. If you have any High Court cases, I am available. So what happened next? Well, there was a split decision. 7 justices went in, 4 judgments came out with 1 final outcome. So Chief Justice Kiefel, Keane and Gleeson dismissed the appeal by the news agencies because, sorry guys, defamation is harsh. That's basically what their argument boiled down to. They said that defamation has always been a situation in which the moment something's published, you're responsible. And publication occurs the moment that happens, whether you wanted to or not. The only question is, were you a willing participant in the publication? And what they said was, you wouldn't have been posting a news story on your page if you didn't want people to interact with it, if you had comments open. You willingly invited third parties to say stuff. And to be honest, you probably should have known that things might not be great because look around, the world kind of sucks at the moment and people are jerks. So even if you weren't aware of the content of a publication, if you were a willing participant, you were responsible. There may be a defense available called innocent dissemination, but you can only do that if you can prove that it was not reasonable for you to have expected something defamatory to have been said. There was another judgment by Justices Gageler and Gordon, who dismissed the appeal for pretty much the same reason, but made some great comments like, a social media page is not the same as a graffiti wall. In case anyone was confused that the definition of the two things was the same, they're apparently not. But what they were saying was that if someone tags the wall of your building with graffiti, you haven't invited them to do so unless it is a designated graffiti wall, and therefore you shouldn't be held responsible if that were to occur. Justice Edelman, who was in a minority, allowed the appeal in part, but said that the general principles stand. So his comment was that if someone posts a comment on your platform that is completely irrelevant to the subject matter, so if someone posted on this, I think Paul Gordon makes terrible jokes during presentations, highly defamatory, clearly inaccurate, but completely unrelated to a story about the weather. And so he would have said, well, it's not willing publication if it is unrelated to the content that you've posted. But that is not the judgment that we have that was in the majority, and that's not the way the law now works. Justice Stewart also said some other stuff. You can read it if you like, but it's not the law, so probably best to disregard it. So that leaves us here with the position that if you have any form of digital page that allows for user-generated content to be submitted, you are responsible for that content the moment it is published. Now, that is frightening, and you may have some defenses, so you don't need to lose too much sleep. But what it is changing is the manner in which moderation in particular occurs. My strong advice, that is not legal advice, my strong general proposition is that if you have a page that allows for comments, comments should only be allowed whilst you are able to moderate it. If you do not have staff who are able to be there after 5 o'clock or on weekends, disable the ability to comment, at least on posts of controversy. If you post a weather post, you've got a risk, but it's a small enough risk. Even if you're doing that, you're still in trouble because you might take it down 2 seconds after it goes up, but if someone else saw it, you're already in trouble. But at least minimises the level of risk that you have. The changes to the Defamation Act may make it harder for people to sue you and your company for defamation, which is great, because you now have both the 12-month single publication rule and also the requirement of serious harm. But the cases keep on coming. So in terms of what you should do if things post things that are unpleasant on your platform, the path that you need to take depends upon the level of control that you have. So first thing to do if it's an owned platform or if it is a platform that allows you to moderate, hide the comment, don't delete it initially, just take it out of circulation. Think about whether or not the content should be taken down because it's unlawful, it violates your house rules, or it's just plain mean. Figure out who posted it and figure out who is impacted and then act. And in point 4, if you want to call someone like me, you can to just get a second opinion as to whether or not you do need to act. But unfortunately, we are in a position now where not acting is not an option. And I remember at the first of these, we're always talking about do not delete being the mantra that we always use in relation to online content. The legal system has decided that, sorry guys, that's not an option unless you want to be tarred with the same brush as the people who posted the content, which is a bit of a mind shift. Now, if you don't control the platform, you need to consider what you should do. So let's say someone posts a nasty tweet. Not much you can do. You can't force Twitter to take it down. Believe me, I've tried. What you can do is report it, post corrective commentary, consider whether or not it is going to be helpful to respond to the post, reach out to the people who are impacted, and try and work out also where the post came from. And that brings us to another interesting area, which is about unmasking trolls. Now, I've been on the pro-unmasking train for a while until this year, because I've just seen so many instances of people who have been despicable in the manner in which they've acted online and just hiding behind the fact that they're using a pseudonym. It is, just to recap from those who don't know, yes, it is possible to unmask someone. I've done it several times. It is, however, long, expensive, and frustrating, because you'll write to Google in the US, who will inform you that unlike what happened last week, this week you need to actually write to Google in Ireland. And then you'll write to Google in Ireland and they'll tell you that you need to file using the Hague Convention for the serving of process. It's an absolute nightmare. But it can be done, and it is worthwhile to do it in certain limited circumstances, such as where the content that is being posted repeatedly no matter how often you take it down, and it is having a serious and severe impact upon your business's operations or that of your clients. If it isn't, it's best to just ignore it, let it fizzle out, become tomorrow's fish and chip paper, to use an antiquated saying. But also remember that the power to unmask can also be used in a semi-destructive way. And I'll get a little bit political here, but not overly, so forgive me. Has anyone followed what happened between Avi Yemeni and PR Guy 17? No? So for those of you who, show of hands, who doesn't know what this is about? Awesome. Get on Twitter more, people. It's all been happening on Twitter. So during the first lockdown, a Twitter account was created with the handle PRGuy17 or PR Guy, using a lovely Troy McClure copyright infringing image, as you can see right there. Number of issues with this. And he started to post very partisan, pro-Dan Andrews Labor government messaging. And he was doing so in a manner which was quite acerbic. It was quite, the way that he has now described it was say that he was using the same thing that the right-wing media are using in their posts, but for the left-wing side. He also got into a few Twitter feuds with the gentleman that you can see on the left there, Avi Yemeni, who is I think the chief correspondent for Rebel News Australia, which is a far-right, conspiracy theorist-loving publication that's out there. And Avi, if you're listening, please don't sue me. I will fight you. But Avi decided that he was sick of PR Guy and he wanted to unmask him. So he sued Twitter. And he successfully had orders made by consent from Twitter. So interestingly, Twitter did not fight this. They didn't do anything. They just ignored it until it was in court. And then they eventually showed up and just handed over the records. And that gave Avi an IP address. PR Guy had been smart and been using a VPN for all of his posts except for the first one that he made, which did not use a VPN. And so Avi then sued Telstra to try and figure out who PR Guy was. Now, PR Guy at that stage decided it was all a bit too much and unmasked himself. His name's Jeremy. He's a lovely guy. But it demonstrates that this can happen. And the thing that was concerning about it was that the commentary that Avi was making was, "I'm coming for you," and the commentary that his followers were making were verging on threats of physical violence. And so there's an interesting legal question as to whether or not it would be possible to block this kind of attempt because it causes a threat to public safety. That is an open question that has not yet been determined, and because PR guy unmasked himself, it won't be determined in this case. It's also interesting that Yemeni, the whole reason why he got these orders was because he was going to accuse PR guy of defamation, but PR guy has yet to be sued. So now that he's out in the open, it seems like the fire's come out of it. Yemeni, to his credit, raised a stupid amount of money from his followers to fund these cases, like over 100K. But yeah, it's really interesting that the unmasking can go both ways. So I'm no longer entirely on the side of everyone should be public at all times and be responsible for what they say, because it can lead to real serious harm for individuals. So moving now on to privacy laws, and this one's a little bit of a damp squib, which is a fun expression to say. 2021 was a very ambitious year. In South Australia, there was a proposed new tort, and this is the finest in law puns that you will find anywhere in the world, I can guarantee you, that being a tort. So a tort is a kind of legal action. It means a wrong in Latin or French or something. But basically the idea was that we were going to have a new piece of legislation that allowed a person to expect a reasonable expectation of privacy. Now this completely would change the landscape, because at the moment, you have no expectation of privacy unless it is in relation to a company or a person who earns $3 million a year or more. So big rollers, I'm afraid you guys have to give all the rest of us privacy. Thanks, Ryan. And then in terms of other health service providers and those who deal in data. But otherwise, no one owes you anything in terms of privacy, and they can do what they like. This would change that. However, this was put forward by Vicky Chapman of the former Liberal government, and Parliament was prorogued. So that's now not happening. But don't worry, we've still got a federal government piece of legislation with the great, super snappy title, the Privacy Legislation Amendment Enhancing Online Privacy and Other Measures Bill, 2021. This was also going to have a major impact on social media, because it would allow for the creation of an enforceable privacy code for social media platforms. There would be greater obligations on anyone in the digital space, so not just the big players, but anyone who has a form of online presence that allows for people to upload personal information would have a greater level of responsibility. There would be greater protection for children and vulnerable groups. The commissioner would get the ability to give out infringement notices. So at the moment, if you breach privacy, the commissioner can go after you for massive fines, but he has to go to court to do it. Whereas this would allow the commission to just slap people with fines whenever they wanted. But then Parliament was prorogued. So in reality, we've had two great ambitious attempts to amend the privacy laws, neither of which have gone anywhere, and neither the current South Australian or federal government have really made any noises on this. Not that they're saying that they're not going to do it, but they've not put out any statement saying that it's a priority at this stage. So at the moment, the key changes to the privacy laws that we were expecting to go through haven't. Now, how are we going time-wise? So at this point in time, I've got a whole other section that I hid behind the questions slide about the Online Safety Act, but we can move on to questions if... let's do questions. If you want to know about the Online Safety Act, come back next year.
You're coming to drinks, aren't you, Paul?
Oh yeah, of course.
You could always hit him up at drinks or sometime during the break. So we have Kaylee and Tori, two of our volunteers here today. Tori's an intern at UniSA, and Kaylee is joining us on Year 10 work experience. So please be kind, but they'll be running around the mics for the questions. So please, if anyone's got any questions, feel free to raise your hands. Is this the first time that's ever happened?
This is the first time this has ever happened. Oh, thank you.
Awesome, here we go. All right, let's start the ball rolling.
So we've been looking at that Voller case for our social media, and one thing that we've had questions from our exec team on has been the difference between hiding versus deleting a comment, especially because on Facebook, when you hide a comment, they can see it, so can their friends.
Correct.
So is that enough?
No. So Hiding comments is not enough on Facebook because it is still visible to third parties unless the person has no friends. So if the person has no friends, you're fine, just in life in general, but also on social media because there's no publication to a third party. If it was the case that when you hit a post, it was still visible to them but no one else, that would also be okay. But because it's visible to their friends, there is still an ongoing publication. By hiding it, you reduce the scope of damage because one of the things that social media court cases have shown us is that the number of views, the number of likes is relevant. But you're not eliminating it. So hiding is a temporary measure whilst you figure out what you want to do. It reduces but does not eliminate your risk, and then you have to make the decision whether to delete or not.
Yep, got another one here. Amazing.
Just on that, if a lot of us manage content for our clients on their behalf, where does the liability go? To the agency or to...
So it will likely be to the organisation who appointed you because you are effectively acting as their agent when you're doing that. So if I'm hired to post content for someone, I'm doing it for them, not for myself. So the liability would rest with your client, not with you. However, if you should have, as a professional marketer, seen and done something about it, then you might have a case coming against you for negligence or breach of contract for failing to act appropriately. So whilst the initial liability, so the person on the street who's angry, would be able to sue your client would likely be able to turn around and sue you. So you get this wonderful little chain reaction of legal cases which make all of us lawyers really happy and everyone else super sad.
And then just the second part, just for an experience we've had personally, is how, say a fight kind of breaks out in your world, not between you and somebody else, but between two other third parties. How deep does the liability go if, say, party A decides to make a very permanent emotional life choice? I think you know where I'm going. How deep can liability go, and what protection options are there in the digital world for third parties?
So that's a really interesting one because we are then talking effectively about personal injury sort of claims, and it comes out back to there are actually caps on liability for negligence these days, which is good for businesses and bad for people who are injured. So depending upon which side of the fence you sit on. I think that the question there is slightly different to what we've been talking about in a misleading, deceptive and defamation context, because those are specific areas of law with very clear rules about when a publication occurs. If we're talking about an evolving circumstance in which things escalate, and potentially escalate quickly, the question will be back to the allergy pathways question of, did you act reasonably in light of what has occurred? I do think that there is liability there. I think that if you are hosting a fight and you are aware of that fight, and it would be reasonable to expect that the fight might lead to people being harmed and you did nothing about it and just sat on your hands, that would be problematic. Definitely one to get the lawyers involved in though, because the level of liability, whilst it is capped, we're talking hundreds of thousands, if not millions, potentially, depending upon the level of harm that occurred.
Okay, I've got a question from Ed over here and also one at the front here. So Tori, if you want to jump here, and Kaylee will take Ed's question first and then we'll move through to the next one.
Hey Paul, great presentation. Just on the hiding versus deleting thing, I work in government. A lot of private businesses can delete whatever they want, ban people, all good. We often get people that comment and they think they have their God-given right to comment whatever they like, whenever they like, and if we delete it, it'll come back 5 minutes later, it'll come back again saying, why did you delete that? You can't delete it. But we just can't ban people. What's your thoughts around that and being reasonable?
Yeah, so in situations where deletion is not really an option, and I must say local government have a lot of problems here because people do care deeply about their local communities and wish to speak about it passionately in a lot of instances. Unfortunately, the law does not make a distinction between the types of content that's posted, and so the council will remain liable for it. What you could do if hiding and deleting is determined to be impractical is to post corrective commentary. That's probably your best next bet, is to, so if someone says, Councillor X is corrupt, and you decide that you don't want to delete that, writing saying, there is no current evidence that Councillor X is corrupt. If you believe there is, here's how you can report it. This is the details of ICAC and of our complaints policy, etc. However, we do ask that you do not further publish this allegation because it is defamatory, and any further instances will be deleted. So, I mean, not ideal, super clunky, but it's the best way you're going to be able to reduce your risk in those instances.
I'm sure everyone in the room has had scam comments on their posts. I'm just wondering, as a page owner or a company, how liable potentially if we leave those up or don't act on those immediately if someone is scammed as a result?
Yeah, you are absolutely in the gun, and we've seen a lot of that happening more and more generally with high-profile brands in particular, not just having things posted on their pages, but also having their logos, ambassadors, etc., posted separately on scams. If you become aware of one, my advice to you is to definitely post about it, saying, do not fall for this, it is not us, it is a scam, because a failure to do so could be criticised if you were made aware of it and didn't act.
Another one here at the front.
It's always the first question that's the hard one.
Yeah, it's always the first question. As soon as someone asks one, it just goes,
Yeah.
I work for the ABC, so one of these media organisations that has to be very careful of the comments on our posts, which we do take very seriously.
My sympathies.
Obviously, it is quite overwhelming some days with hundreds or thousands of comments that you have to moderate. Do you think this is the end of it, like in terms of the onus being on the organisation rather than...
So no, for two reasons. The first reason is the Voller case to date has only been on the question of publication. So that's the question of, did the news media outlets publish the third-party comments? And the answer is unequivocally yes. What it hasn't looked at is whether or not the defence of innocent dissemination, which I mentioned briefly before, would have applied. So the case is not over. Voller has not won and had squillions of dollars yet. That is the next step that we're going to look at. The other thing is that the Morrison government proposed amendments to legislation, to the Defamation Act, basically to undo the court decision. Once again, Parliament was prorogued, so it's no longer an active piece of potential legislation, but I would expect, with the amount of lobbying that the media companies are doing on this, there will probably be legislative change. Now, whenever there is legislative change, it creates uncertainty as well, because we don't know how the courts will then interpret that legislation. But my expectation is that probably in the next 3 to 4 years, law moves slowly, we will see a change. How far it's going to address the balance, I don't know.
Fingers crossed. Yep, one at the back, and then are there any other questions? Anyone else got questions? We might take this one as there's one in here as well. So last two questions, and then we'll go to monitoring.
You sort of highlighted the legal ramifications of content you're posting on a social media channel. How, as a business that hosts other people's content, where does the liability lie there without having methods in place to moderate content if it's user managed and maintained content?
Okay, so we then start looking at cases about the big platforms, so cases such as Janice Duffy's fight against Google and Triculio against Google. So the answer is the platforms are liable for what is published. The question of when publication occurs is the same, so you are responsible as a host. The other thing that you need to be aware of, more than just people who use existing platforms, is the Online Safety Act has now put in even more obligations on you in relation to third-party content, and you providing what's called a basic online safety expectation for users of your site. So it is, unfortunately for platform hosts, now a very challenging regulatory framework, and one that if you're not across, you need to get across quickly because the penalties are huge.
So would that still apply if I'm say for instance a web host hosting people's websites?
Yes.
That's something new. I think we are going to make the slides available so we can all catch up on the Online Safety Act afterwards. Last question, I think, here in the middle, and then we'll be breaking for morning tea.
Just piggybacking off the spam kind of question, if you get hacked and someone takes over your account and then scams somebody, are you still liable, even though you might have done everything you can to not be hacked, like two-factor authentication and stuff?
So the question will always come back to the reasonableness of your actions. If you are handing out slips of paper with your account username and password, just at parties, which I often do, then it's a risky way to live, but the thrill is amazing. If not, if you're doing everything right, if you're doing two-factor authentication, then no, you are not going to be responsible for that occurring. But once again, it is important for you to take remedial action as soon as you can. The other thing to remember if you do get hacked is, and even if it is a ransomware attack, which a lot of people don't think about this issue in ransomware, is if you are a Privacy Act regulated entity and you are hacked, you almost certainly have a notifiable data breach that you must investigate and report to the Information Commissioner. People think, well, hang on, they just came in and encrypted all of my stuff, no one's seen anything. The fact that they got into your system and could have looked at your stuff means that you may have a privacy breach as well.
All right, on that note, Paul, are you hanging around for morning tea?
Absolutely.
Awesome. So if you've got any follow-up questions, feel free to bail him up. Just don't ask for legal advice, otherwise you might start charging on the clock. I want to thank you so much, Paul, for your time. Destroyer of marketing dreams, you're always welcome at the conference. Some really valuable insights.